Hello, ladies and gentlemen, veterans, dedicated VA employees, and everybody watching this video today. Thank you so much again for coming back to my channel and watching another video where we discuss VA disability. As always, my name is Attorney Matthew Lang. I'm a VA accredited attorney. I've been working VA disability law for more than 16 years now. Not always as an attorney. There was times where I worked within the VA and now I work outside the VA. I was a claims developer, a decision maker, a supervisor, a trainer, a mentor, and even an attorney for a brief short period of time in the VA. Out of all my time, there's a lot of questions I receive from veterans. And a lot of questions are repeated over and over. So today I want to do something a little different. As you can see, I put on my relaxed clothes today. Still working hard for all the veterans out there. But let's take off the tie, let's take off the collared shirt, the suits, and come off this Labor Day holiday just answering a few questions. So I have a list of 10 questions in front of me that are, I feel, very common from the series of questions that I do receive in my practice. And I want to answer those 10 for you today. So let's get started. The first question is my VA disability payment that I receive every month, is it taxed? And no, it's not. The great thing about your VA disability payment, outside of the fact that as veterans we receive such a benefit, is that it is a non-taxable benefit. You don't have to pay taxes on it. There's no taxes withdrawn from it. This is not Social Security. It's completely tax-free. The second question I receive, is it normal for the VA to request an exam even though I provided a DBQ? Veterans, I have to give you the unfortunate answer that yes, this is usually the case. The VA, in my experience, I see you probably 99% of the time request a VA exam even though a DBQ is provided. Now, veterans, keep in mind, since I don't know the facts of your case, it could be possible that that exam is necessary, depending on what's going on in your case. But I would say that 99% of the time, it's in my experience anyways. Now, again, I would get with your representatives or whoever's helping with your claim, if you have anybody, to make sure with your facts. But it's usually not needed. The exam that the VA requests is not needed. The DBQ's purpose is to fulfill that requirement, and when it was put in place, that purpose was to help break up the backlog that occurred with requesting VA exams. And for some reason, over the years, and especially when I worked at the VA and still even today, VA has failed to understand what their duty to assist is and actually utilize the DBQ properly. Request exams, which only backlog the VA more, and is completely counterintuitive to the purpose and the mission of that DBQ. But again, veterans, just remember, it's possible that exam is still needed. So kind of take that as what you will. But unfortunately, yes, due to what I've experienced, and in my opinion, the VA struggles to understand what their duty to assist means. And they think in order to cover themselves, they must always request a VA exam, which ultimately becomes more harmful in many cases than helpful. But let's move on to number 3. Now, number 3 is an interesting question that I've received. Maybe not quite that often, to tell you the truth, but this one I actually threw in there just because the uniqueness of it. We know that DBQs can be provided at this point from a private physician, but we can also provide as evidence, veterans, you can provide as evidence for your claims these nexus opinions, these independent medical opinions. The law completely allows it. It's even mentioned in the VA's manual and their guidance that they're allowed. But the question I get, though, is can I, as a veteran, write my own nexus? No. Now, I say no, there is one slight exception, but let's start with the no. Veterans, a nexus statement is an independent medical opinion that has to be written by a qualified medical professional. Depending on what you're claiming, depends on maybe who that professional has to be. in some cases, like a psychiatrist, psychologist, you might get away with a nurse practitioner in certain joint conditions, for example, but it all depends. The point is that you can't go writing your own nexus and providing that to the VA. It has to be done by a qualified medical professional. Now, excuse me, the potential exception, and this is not, again, guidance because I don't know the facts of your case or your situation, and you would, if you have a representative, check with them on this strategy, but the one exception may be that you could write your own if you are a qualified medical professional. But I really caution that from my practice. Now, I'm not saying that other representatives are against it or how they handle it, but just know there's always an exception to the rule, and it's there, just so I can answer your question properly. But ultimately, the basic answer is no. You can't be writing your own nexus statements. That's for medical professionals to be writing. So here's another huge question I get all the time. Here's number 4. So the number 4 question is how do I file for the PACT Act? Now, I think there's just some confusion. Maybe it's the way the question's worded. But veterans, you don't actually file for a law. When you file a disability claim, you're filing for that, a disability, a condition, a diagnosis, something that is medically proven. So the PACT Act in itself is a law. So you don't actually file a claim for the PACT Act. And like I said, this may just be the confusion of the way things are worded. So just understand, though, on the black and white part of that question, you can't file for a PACT Act, but you essentially can, and I think that's where the confusion is. So you're not filing for the PACT Act, you're filing actually for a condition that law says is presumptive to a specified location that you would have served in. So ultimately, when you file a claim, you can really put down, say, asthma or sinusitis or rhinitis, which are the 3 huge ones that I work with back here in my practice that I see associated to the PACT Act. If you say you've got sinusitis or rhinitis, say, through qualifying locations in the Persian Gulf or the Gulf War, which goes on from 1990 to present still by definition of the law, maybe you served in Iraq in the example, then yeah, you would put down something like rhinitis due to service in Iraq or due to rhinitis associated with PACT Act or something like that. So I guess I kind of see how the question comes out, but keep in mind that you're not actually filing for the act, you're filing for the disability listed in the act. So you really just file for that disability and try to make that connection with your service. Just in general, if you need help with filing a claim, you can always come to my website, veteranlang.com, hit the free case evaluation button. We'll have a phone conversation. I could talk you through it or maybe even represent you in your claim, whatever we decide in the conversation. But if you don't want to do that, totally fine as well. Seek out VSO, seek out other accredited representatives you can file through. You can file online through the va.gov website, which is also known as e-benefits at times. You can also walk in person to a VA regional office and file there at their public contact station. So there's definitely some routes that you can file a claim. Number 5 here. Now this one is also fairly common, and I think there's some confusion with this one as well. Not really by the wording, but just because there's 2 decisions involved. So the question that I get is, can I appeal a proposed decision to reduce benefits? No. The proposed portion of the decision, that's that first decision that comes out that says we propose to reduce your benefits due to something as sustained improvement or some sort of improvement in condition A, B, or C, is that. It's a proposal. The action hasn't been taken yet. And because the action hasn't been actually taken yet in a decision, there's no appeal right afforded. Now, that doesn't mean you can't argue against a proposal. It's just you won't follow the appeal lanes that exist, like this supplemental claim, the higher level review, or the notice of disagreement to the Board of Veterans' Appeals. You will get other rights. They'll be in your letters talking about requesting hearing and submitting additional evidence to change the VA's mind. But once that proposal becomes a final decision and the action's taken, yes, now you can appeal that second part of the decision. And I think that's where the confusion comes, is it's not normal to really in the process to receive two decisions. So that proposed decision, I think everybody wants to appeal because that's kind of the norm with everything. But no, a proposed decision can't be appealed, but it can still be argued through either, again, a hearing, additional evidence. And sometimes there's nothing needed at all. VA just, I've seen it messed up, and then the person who gets it next realizes the proposed is an error, and they just overturn it anyways. Not that I would veterans rely on hope on that part. Anyhow, but yes, that's the answer to that question. You can't appeal a proposed decision to reduce a benefit. Now, going along with that, this is the other question that usually comes up with a proposed decision to reduce and the reductions. So if my benefits are reduced, will I have to pay back any money for my benefits for that overpayment? And the answer is usually no, especially if it's an improvement case. The way the laws work is if the VA, you put the final decision on that proposal and you actually take that action, the effective dates of all that usually go out to a future date to avoid any such overpayment. And if it goes back and says severs a benefit, takes it completely away from you, or drops it down to a previous date in the past, say due to a clear and unmistakable error, so if the VA discovers that they messed up and they're going back and redoing everything, no veterans, you don't have to actually pay back that money. That's the VA's error, and you're not going to get punished for that. Now, if they try, again, veteranlang.com, let's have a conversation. But ultimately, in pretty much every case, no, there's nothing to pay back. Now, keep in mind, again, law has exceptions. If it's discovered your case was fraudulent, you're looking at paying some money back. But otherwise, no, not usually. So here's another. This is another great question that comes up all the time. Veterans, you get 100%, and you always want to know if you're permanent and total, and how do you tell? Well, the easiest way I'm going to give you to tell is go into your eBenefits VA.gov page or the VA app if you have it on your phone. It's actually a really handy app. I actually enjoy. May work many times better than the website, unless that's just me. But you can actually print a benefits summary letter there, and forgive me if I'm calling it the wrong thing. It's on the website or the app, but you can print this letter off that will actually tell you what your overall is, the effective date to it, and it'll actually state yes or no whether you're P&T, permanent and total, underneath it, 100%. Now, I give you this, veterans, as the answer. It's really the easiest way to see it, but at the same time, you should check your states, depending on where you live, because each state has additional state benefits that could include issues with property taxes or car registration, hunting, fishing license, and all kinds of things. But if that benefit requires, from your state, requires you to be P&T, they're going to require that letter anyway, so go ahead and print it off. Take that letter, look at it, see that you're P&T, and inquire with your state. So yeah, that's the easiest way right there to tell. There's a lot of other convoluted ways, but I'm not going to confuse you with how to dig through hundreds of pages of figuring it out when we can just do it on one sheet of paper. So yeah, just print off your benefit summary letter. If that's not the right one, yeah, I know there's a few other choices in there. Just click away. The right one's in there. Yeah, it'll be listed. Oh, this is huge. Can't believe I saved this for towards the bottom here. So number 8, how long will it take the VA to decide my claim? Veterans, I can't tell you. I don't know. No one really knows. I don't think sometimes the VA knows. Sorry, VA. Well, kind of throw that at you, but the facts of the case could vary. Could create additional time for a decision. I mean, if the VA is having difficulties obtaining, say, your service treatment records from the service department, or some personnel records, or some records from your private providers, just any kind of evidence that they're supposed to go gather or help you gather to a certain extent, that could make your claim go longer. If an exam is actually needed and you're going back and forth and trying to get that scheduled because you don't have time for whatever reason, veterans, that could delay the process. It could cause the VA to request exams and take much longer. The other reasons that could be that your claim could take a different amount of time is just, well, logistics in the VA. The VA works on what they call a national work queue system. It's all computerized. There are some people pushing buttons. There's some algorithms. There's a bunch of technical stuff that it's probably over everybody's head. That could cause delays. I mean, system errors alone I've seen cause delays. If the VA is not catching their errors, claims will sit there for sometimes a year, maybe more. If no one catches those errors, I know I do my best to identify those errors with the VA, with my knowledge and experience inside the VA and working with that system that they have. Unfortunately, not always are they receptive of my opinions, but to each their own. So VA, just know your system sometimes blogs causes delays. Veterans know sometimes it's just the facts of your case. It's part of the business, the part of the process may cause delays. So it's really hard to tell you when your claim will be decided. Now, but what I do tell you is the VA does have, in general, a goal of 125 days on average to complete your claim. So, I mean, your claim could be processed within one day. I've seen that. It could take the 125 days. It could be 30 days. It could be 40 days. I mean, there's so many moving parts in there. It's hard to say in the end. But if your claim does happen to go over that 125 days, so you got a rep, I would say, and see what kind of pressure can be added to the VA. We'll do what we can. I know I do, and I know others out there that will as well. So just know, unfortunately, there's no real good answer to that question. 125 days is usually the goal on average. All right, let's see. Question 9. Well, this is huge too. Am I allowed to work if I am getting 100%? Well, yes. Veterans understand that the law is even written in a way knowing that you will likely still need to work or be capable of working if you got 100%. That you'll probably push through whatever condition you have just to support yourself, your family, and loved ones all the way around. There is no actual bar in the laws that says you can't work if you're getting 100%. So if you're now, again, there's different rules that may play. Depends on your case, but know that in general, yeah, you can still work. Now, if you're permanent and total, yeah, there's really no true limitation at that point. It's been decided. It's done. Now, if you're getting 100% underneath a temporary, say underneath an IU, an individual employability, a TDIU kind of issue, yeah, there's some other rules that play in there. They don't prevent you from working though, but you may be looking at making a much smaller income in order to be able to work and collect that 100%. But overall, basic answer is, yeah, you can still work. All right, number 10. We got down to number 10 here. Number 10 that I usually see is, can I submit new claims while my appeals are pending? And again, always check with your representatives, accredited representatives, veterans. But yes, the basic answer is yes. You can always submit a claim anytime you want, as long as it's not the same. You're not trying to resubmit the same claim that's already processing. Whether that be an appeal, a new claim, an increased claim, feel free to always submit your claims. VA is wide open to it. But again, I will give caution that I don't know the facts of your case. You may want to consult with your representative, accredited representative, just to make sure that they don't see a problem. But I would say likely, in my experience, there's not a problem. But again, I'm not here to advise you. I'm just going to answer your question in general. Yes, you're allowed to do so. Anyways, Veterans Day KV employees and everybody watching, I greatly appreciate again you taking the time to sit here and be casual with me. Nice to just relaxed, answer a few questions. I think this is a great start to get conversation going, discussion going. If you have any further questions, please leave them in the comments. I will go back and put together other videos where we can actually answer these and we can have some discussion. That's the whole point of these videos, to get a discussion going, get information out there, learn about VA disability, whether it be general overviews, OAG reports, other experiences that we've had, answering questions just like we have today. So there you go. Thank you again, everybody. I will leave you with the option to subscribe, like. Please share the videos if you like them. Share my channel with all other veterans and VA employees and anybody who is curious to watch. It would be greatly appreciated, so we can really get out there in the community and help make this process much easier. And always, you have my website, veteranlang.com. You can refer to schedule a free consult or case evaluation with myself personally to see what we may be able to do for you, or what I may be able to do for you on your VA claim, and my team. So, thank you again. Have a wonderful day and a wonderful week.